Going to call the Judiciary Committee to order. Madam Clerk, will you please call the roll for attendance?
Chair Lightner.
Here.
Representatives Begol.
Here.
Wozniak.
Here.
Harris.
Here.
DeBoyer.
Here.
Johnson. Here. Schutte.
Here.
Carter. Hope. Here. Breen. Scott. Madam Chair, you have 8 members present. You do have a quorum.
Thank you, Madam Clerk. Rep. Johnson moves to adopt the minutes from September 10th. Hearing no objection, the minutes are adopted. Rep. Harris moves to excuse absent members. Hearing no objection, absent members are excused. All right. Right now on the agenda, House Bill 4781 is slated today, but we are going to pull that from the agenda as we continue to work through some issues with that bill. I'm going to go at ease for a moment. All right, we're back to order. Right now, we're going to skip over voting, and we'll come back to that. And I am going to go ahead and call up Rep. Aragona, Hoadley, and DeBoyer in regards to House Bill 4481, 4482, and 4483. Gentlemen, you have the floor.
Thank you, Madam Chair, and members of the esteemed committee, sort of. And thank you, honestly, thank you very much for considering this legislation. So this legislation has to do with CPL specifically and is intended to aid CPL carriers, people who have CPLs and then exit our state in order to help them be compliant with other state laws. So what this will do, and if you don't mind, Madam Chair, I'll just kind of highlight the different bills. House Bill 4481 creates a website that the Attorney General will maintain. 4482 requires that website be updated every 60 days. And my bill 4483 requires a QR code on a CPL. So for those of you who are unfamiliar with a CPL, this is a CPL license. It's we have a variety of guidelines that you will get. Or that you have to go through in order to obtain one of these in Michigan. And what this would do is just ensure that there is a QR code on here for any of us who have a CPL as we leave the state to ensure that we're compliant with other states' guidelines. That's one of the things as a CPL holder. If you leave the state, a state like Indiana might be far more compliant. If I happen to be carrying my weapon, I go into Indiana, if I get stopped, or if I, pull over or what have you, generally Indiana seems to be pretty compliant with Michigan laws. If I go into a state like Illinois, they tend to be a little different. It's better in a state like Illinois if I'm driving through to pull over before I go through Indiana, and likely the best case scenario in a state like Illinois is to lock my weapon up and keep it out of reach. So we have 50 beautiful states in this country. What happens and what do I do and how do I make sure that I'm compliant with those laws in each one of those states? So this bill package is intended to ensure that that information for each of those 50 states is readily available as well as accurate to any CPO holder who leaves our state. So with that, I'll turn it over to Reporter.
Great. Thank you, Chair Lightner and committee members. Rep. Aragona described it and broke it down really well. But what I'll add to is why the state should do this. The reason is it's the government that is restricting our Second Amendment rights. So I feel it's the government's responsibility to make sure that we are in compliance with what those laws are and having the availability to have that information upon traveling. There are numerous stories of people that have had their weapons confiscated, jail time, wrapped up in court cases by unintentionally carrying in a state that didn't have the reciprocal laws that Michigan does. And that could even be inadvertent. Now, there's a story of a gentleman that was arrested that had a firearm and confiscated from him as he flew from Utah, and he checked the firearm laws for where he was going, but his flight got rerouted. And when he was landed in a different city, they didn't have the reciprocal laws, and he ended up getting arrested and his gun confiscated. So we want to avoid those kind of disasters for law-abiding citizens and CPL holders.
Yeah. So 4481, which essentially is just the bill that would require the Attorney General's office to establish the website that provides that information. We as legislators, we're kind of immersed in this, and we understand process, at least as far as legislative acts go. But the truth is the state of Michigan has implemented the requirement of a concealed pistol license, which definitely restricts your Second Amendment rights. And I do believe that it is the state's responsibility, if they're going to continue to obviously enforce the concealed carry statute, to provide the pertinent information to the citizens of the state of Michigan with regard to their rights, obviously in the state of Michigan, which they already do, but secondarily in the states that have the reciprocity that allow for Michigan residents who have a valid concealed pistol license to carry in their state. I think it's just a basic service that we should provide because, again, we are the ones that have been putting these restrictions in place as the government per se. So I think that it's a rather simple ask. It's a rather simple process, but I think it's going to be a very helpful process to the citizens of the state of Michigan.
Yeah, and just to add on to what Representative Hoadley was talking about, where there are times where people are actually being convicted in another state. There's another resident of Pennsylvania who was driving through one of the East Coast states, and she ended up spending almost 50 days in jail because she was compliant with the Pennsylvania laws, but she did not realize that she was out of compliance with this other state's laws. I'd like to make sure that CPL holders in Michigan aren't subject to that, or at least make it as easy as possible to ensure that they are following other states' laws. CPL holders, they tend to follow the laws about 10 times more than others. Conviction rate as of a year or two ago for CPO holders for crimes is about 0.24%, whereas the population as a whole is about 2.4%. So we're just trying to help law-abiding citizens follow laws, not in Michigan. Thank you.
Thanks, fellas. I have a question. I mean, obviously, recently I traveled as well out of the state of Michigan to another state that has constitutional carry. But I just got on the national website and checked the laws. And, fortunately, both of my flights were direct, so I didn't have any issues. But is there an instance where our Attorney General could just, or because that's where you placed it, first of all, under this legislation, I don't know if it was you directly, but where the onus is placed on the Attorney General, could they just have that link to, rather than rebuild a new website and reinvent the wheel, can't we just link it to the national database that has all the states there already, and then you just check it yourself? It just gives you a quick link rather than spend the money to build something new?
Yeah, that's a great point. We could. The issue that we're trying to get to is that we want to make sure, and I think as of last I checked with my staff, we were trying to figure out exactly how often that's updated, right? So in this package of bills, it says that the Attorney General has to update it every 60 days. We want to make sure that this isn't going 6 months, a year out, and it's not being updated. And as we know, especially in our political environment, many, many things can change. Good or bad with this hot button political issue. We just want to make sure that people are compliant with the law.
And with the QR code, it makes that information in real time too, while you're traveling, not, having another little detail to worry about as you're traveling through multiple states.
Well, the QR code's just a link to that website, right?
Correct.
Is, if I may, Madam Chair, are you going to the USCCA website, the national?
I don't know. It probably was. It's just, when I traveled, I wanted to know because obviously in this political climate, and also as someone who doesn't, necessarily walk around with security, I like to have my own security. So my Sig Sauer 320 is a nice little piece to carry with me. And I'm a big girl, so I can carry it well. I want to make sure I'm not going to get arrested because I have also driven through Illinois and had to stop at the Cabela's right at the border and buy a case and a lock, and because I was like, oh shoot, I forgot it, but fortunately it's right at the border.
I would just say that my concern with relying on that website is we're linking to that website, which I think would put a false sense of accuracy in the minds of the individual that's linking to that website, believing that it's going to be accurate because we're using it. I would be much more comfortable putting the onus of the accuracy of that website on a state agency, specifically the Attorney General's office, because that's where all the lawyers reside that can look at these laws and make at least an educated determination on how those laws would apply to us, as opposed to trusting, in this case, the example I brought, the UCCAA. And so that's why I'm much more comfortable with us having our own website.
Rep Harris.
Thank you, Madam Chair, and thank you guys for bringing this forward. I think it's a very useful tool. I've been teaching CPL classes since 2001, and after putting a couple thousand people through, we typically get a lot of questions, right? And this is one of the things: is where can we go to find accurate information? Question following that statement, though. So, is there anything in the bill that talks about the liability for if maybe there's a period of time where, say, California changes the law, and maybe it takes 2 weeks for the Attorney General's office to update that? Is there something that still necessarily puts the onus on the CPL holder, but our website at the state level, and I'm just thinking liability-wise, if somebody were to get arrested in California because of a brand new law that just, got enacted, is there a period of time or a waiver that we would have on our site to protect the state from liability, but still put the onus on the Attorney General to make sure this thing is updated on a regular basis? So it's a good reference material, but I just want to make sure that we're not putting the state in a tough bind too.
Yeah, that's a great point. I would hope it wouldn't fall within that period, obviously, just because it is such a short period. But we can definitely take a look at that, whether that would be in some type of administrative rule, or I would be comfortable actually adding it in if you think it would be good to actually spell that out in state law.
Or as simple as a disclosure, that as the CPL holder, that you are ultimately responsible for following the laws, and this is a helpful tool because the website is to be updated every 60 days, so I get your concern when there's a 2-week-old new law in California or one of the crazy East Coast states.
Great. Thank you, guys.
Rep Wozniak.
Thank you. Any idea how many states have reciprocity?
I can't give you the exact number, but it's in the 40+ range. Yeah.
If only there was a QR code I could reference on the back of my CPL right now as you ask that question.
Yeah, as of right now, there's about 39 states with reciprocity.
Okay. Thank you, gentlemen. In regards to House Bill 4481, 4482, 4483, Brian Darlis, representing Palladian Academy, submitted a position on the bills in opposition, and already submitted written testimony to the clerk. Okay, next up, we are going to take up House Bill 4840. And as I talk about this, I will have Judge Yates from Michigan Judges Association, Judge Doug Turing, and Judge James Alexander, who all support the bill and wish to speak. And I'm going to go ahead and talk about this real quick. House Bill 4840 clarifies existing law by ensuring that litigation among owners of privately held corporations and LLCs are assigned to Michigan business courts, regardless of whether the corporation or LLC itself is named a party. Currently, business court judges across Michigan apply different standards when determining whether shareholders or member disputes belong in the business court. This inconsistency creates confusion and inefficiency in the judicial process. In some cases, judges have declined jurisdiction over cases that clearly concern business ownership disputes. Additionally, enforcement of judgments can be further complicated when those proceedings are transferred to different courts, separating them from the judge and venue that handled the original case. This legislation will standardize business court procedures by clarifying that such internal business disputes should be assigned to the business courts, and that proceedings to enforce judgments in these cases should remain with the original presiding business court judge. With that, I'll let you gentlemen have the floor. Thank you.
Thank you, Madam Chair, and thank you for hearing testimony on our bill today. Although I'm now a judge on the Michigan Court of Appeals, I ran the business docket in Kent County for more than 10 years, and I was one of the people who provided some guidance as the legislature was putting together the original business court statutes about 12 or 13 years ago. What we've discovered with the statutes is that the jurisdiction of the business courts is defined almost exactly as the business court judges would like it. But as we work with the statute, from time to time we run into a small problem where a case is misassigned in our view. And so we've come to the legislature before asking for some minor amendments to solve those problems. Judge Alexander and I were before the House and the Senate, I think about 6 years ago, with some minor changes, and the legislature made those changes, and the business courts work better because of them. This is another one of these small changes, but I think it's important. The way that the statute's written now, as interpreted by the Michigan Court of Appeals, is that when you have disputes among members of a limited liability company or among shareholders of a corporation, but the limited liability company or the corporation is not named as a party, the case is supposed to go to the general jurisdiction courts rather than the business court. And in all of our view, I think that's incorrect. Now, they say if you get a decision from a court that you think is inconsistent with what the legislature intended or what the legislature would intend if they'd thought about the problem, then the solution is to go to the legislature and ask for a change. And that's what brings us here today. I have with me Judge James Alexander, who was a longtime business court judge in Oakland County, and Doug Turing, who is one of the leaders in the business law section of the state bar. I had the good fortune to be the chair of that section 2 years ago when the decision came down from the Court of Appeals, and we moved almost as quickly as we could to try to think of a way to address the problem. We believe that this bill would put into law the proper understanding of disputes among members of limited liability companies or corporations and their right to be in the business court. Thank you so much, Madam Chair.
Chair Lightner, members of the committee, thank you very much for having us here today. I'm not going to add a lot to what Judge Yates said. He's a Court of Appeals judge. I was a simple trial judge in Oakland County. Representative Schutte, good to see you. Tell your dad I say hi, please. I kind of grew up together in this business. One of the things, if you look at the statute as it now exists, the purpose of the business court was to create consistency and expertise in the business court judges and help businesses look for that, because you all know that businesses want consistency in order to do business in this state. One of the problems with all legislation that I found out when I went, not with all, but with legislation I came to the bench, is we go so far and then we, practically speaking, we need to go a little bit further. This bill simply adds clarity to what cases go in the business court. If you have a shareholder dispute and the business is not named, that now goes to a general jurisdiction judge. A shareholder dispute is a business dispute. And the problem becomes you don't name the business. If you name the business, who's going to represent the business? If you have 50-50 shareholders, they're fighting, nobody wants to pay the legal fees for the business, that belongs in the business court where business judges with the expertise can make those decisions. So that's one thing. The other thing is a very simple cleanup. The statute as it now exists says that business court judges cannot do post-judgment enforcement, do not have post-judgment enforcement jurisdiction. This gives us the opportunity to handle the cases that we adjudicated and do the post-judgment collection process. So thank you for taking this up. Chair Lightner, thank you for introducing this.
Madam Chair, members of the committee, my name is Doug Turing. It's my honor to present briefly in support of the proposed amendments. I'm a partner at a small business litigation firm, Mantis, Honigman, and Troy, and I'm a former chair of the business law section, and I chair the business courts committee and the commercial litigation committee, although I'm appearing not on behalf of any state bar committee, but on behalf of myself and someone who's just generally interested in business courts. I've written, we have a regular column in the Michigan Business Law Journal on the Michigan business courts, and I've been responsible for the part on Michigan business courts for an annual ABA publication, and I've done that for a number of years. The business courts, the legislation was passed in October of 2012 and became effective statewide in January of 2013. I think by all accounts it has been an outstanding success, and it's become almost so much of part of the fabric of the jurisprudence in Michigan that even for those of us who've practiced longer than, more years than we care to admit, it just seems like we always had business courts, but that really isn't the case. What we have here are basically two what I would call clarifying amendments to what we call the shareholder oppression statute and the LLC oppression statute. Those are statutes in the Business Corporation Act and the LLC Act that govern disputes between business partners. And so if you have disputes between business partners in small, closely held businesses, often they're decided under one of those two statutes. The owners of these companies have worked together in many cases for years and in some cases for decades. And the company is a central part of their life and, of course, is a central part of the litigation. And so the issue is, should these kind of cases be in the business court regardless of whether the company happens to be named as a party? And my opinion is yes, and I've not heard anyone who would really take a contrary opinion. Whether the company is a party or not shouldn't affect whether the case goes into the business court. Cases like this usually deal with issues involving the value of the company, financial issues, fiduciary duty issues, accounting issues, in some cases forensic accounting issues. The business court judges have specialized training in many cases, and Michigan Judicial Institute is responsible for providing that. And many of them have many years of experience on the business court dealing with these specific kind of disputes that can be not only have significant business issues, but family issues that can be entangled with them. And so these are very uniquely suited for the business courts. And so whether the company happens to be a party or not, we believe these cases should go to the business court, and it should be the experienced business court judges who decide those cases. The other one, as Judge Alexander was mentioning, is just simply another clarifying amendment that if there are what we call proceedings to enforce a judgment, if there's a judgment of the business court and it's got to be enforced, that should stay in the business court. I think many business courts, business judges are probably doing that already, but this would clarify that if there's a judgment from the business court that needs to be enforced, it stays in the business court. It doesn't go back to a court of general jurisdiction. So we believe that these are clarifying and non-controversial amendments, and we appreciate your allowing us the time to explain that. Thank you.
Thank you, gentlemen. Rep. Breen has a question.
Thank you, Chair. Thank you, gentlemen. I'm just curious about general court operations. I think this bill is fine. No problems with it. I'm just wondering, are business court cases automatically added to the docket, and is there ever an opportunity for the parties to opt out of it if they want to, or is that something you haven't seen?
The statute itself builds in a process where the decision to assign a case to the business court or not is reviewable by the chief judge of the circuit. And so if somebody is displeased with a case being assigned to the business court, they can ask the chief judge to move the case to the general jurisdiction docket.
Thank you.
Rep. Wozniak.
Thank you, Madam Chair. If we have litigants that have been members of an LLC or corporate shareholders, and one of them dies, where does the case go? Or are there similar or concurrent cases in the business court and the probate court?
Yes, there is concurrent. There are concurrent cases. I tell the story. I had my first case on the business court in 2013. In 2022, I mediated part of that case. It was the death. It had gone through my court, then went into probate court, and I was mediating it 12 years later. So yes, you can do that. You try to keep it all together. The estate can be part of the litigation in circuit court.
Okay, thank you.
Thank you. Thanks for the question.
Rep. McGoal.
Thank you, Madam Chair. Thanks for coming here today. My question is, how many business courts are there in Michigan? And would it require the litigants to travel long distances? In other words, is there one up on the UP, or would they have to come down to Kent County or Oakland County? Or
The way the statute's written, in any circuit that has 3 or more circuit judges, there has to be a designated business court judge or more. In Wayne County, for example, they have 5. In Oakland, there are several. But in the smaller counties, the smaller circuits, there is no designated business court judge. Now, it is the case that parties can put provisions into their contracts that will define the forum where the case gets decided. They could say, all disputes must be resolved in the U.S. District Court for the Western District of Michigan. Or, for example, they can say it must be decided in a business court in a certain circuit. So I had the occasion to get a case from the Upper Peninsula over a sawmill in front of me when I was a business judge in Kent County. And I asked the attorneys when they first came in, how in the world is this case in Kent County? And they said, well, our contract has a forum selection clause that says all disputes must be resolved in the Kent County Business Court. And so I decided a case from the Upper Peninsula. Venue is one of those things that requires some connection to the forum, but obviously the parties can waive concerns about venue if they choose to be somewhere else. And so we've seen from time to time people have written that into their contracts.
If I may also add to that, I believe either 16 or 17 of the circuits have a business docket, but a business, in most circumstances, a business court judge also handles non-business cases. And so most business court judges have either general civil cases or criminal or both in addition to their business docket. But the business court statute, section 8033, establishes one of the purposes, and one of the purposes, and it's mentioned twice, is efficiency. And we believe that this can promote efficiency. And in my experience, the business court judges in general have really done an excellent job in efficiently resolving business disputes that can sometimes have paper like this. And I think that, frankly, sometimes the general civil judges are glad to have the business judges around, so they can say, we'll be glad to have you handle this.
Well, thank you, gentlemen. We are all set for now. Thank you. Okay, next we are going to move on to voting and discussing House Bill. We're going to start with House Bill 4690, and then we'll do 4691. And just to let the members know, there is a substitute for both of them. And well, I'll talk about the sub right now. So the sub in 4690 and 46911 or 4691 are pretty much the same. It's in regards to the 4th degree fleeing and eluding offense. Under the current bill, it shows 182 days as a mandatory minimum. And, after discussion with some stakeholders and such, we actually made it, the penalty stay the same. So 4th degree doesn't actually carry a mandatory penalty for jail. It would still be up to the judge to decide what they're going to do there, anywhere from 2 years to $2,000 as a fine. However, we all know that there's plea deals every now and then. And so if there's actually a prior conviction for a fleeing and eluding of any degree, especially 4th, what the sub does is the sub says if there is a prior conviction, that there would be a mandatory minimum of 30 days. That was kind of a in-between time that stakeholders could live with, that still, carries a penalty for immediate jail time and immediate consequences. So that's what the sub is. Okay. All right. With that, I'm actually going to move to adopt the H1 sub to House Bill 4690. Madam Clerk, will you please take the roll?
Chair Lightner.
Yes.
Representatives Bagul.
Yes.
Wozniak.
Yes.
Harris.
Yes.
DeBoyer.
Yes.
Johnson.
Yes.
Schutte.
Yes.
Carter. Hope.
Yes.
Breen.
Aye.
Scott. Madam Chair, you have 9 yeas, 0 nays, and 0 pass. The substitute is adopted.
Thank you, Madam Clerk. Rep. Bagul moves to report House Bill 4690 as substitute H1. Madam Clerk, please call the roll.
Chair Lightner.
Yes.
Representatives Bagul.
Yes.
Wozniak.
Yes.
Harris.
Yes.
DeBoyer.
Yes.
Johnson.
Yes.
Schutte.
Yes.
Carter. Hope.
No.
Breen.
No.
Scott. Madam Chair, you have 7 yeas, 2 nays, 0 pass. The motion prevails.
Thank you, Madam Clerk. Next, we're going to move on to House Bill 4691. Rep. Wozniak moves to adopt the H1 to House Bill 4691. Madam Clerk, will you please call the roll?
Chair Lightner.
Yes.
Representatives Bagul.
Yes.
Wozniak.
Yes.
Harris.
Yes.
DeBoyer.
Yes.
Johnson.
Yes.
Schutte.
Yes.
Carter. Hope.
No.
Breen.
No.
Scott. Madam Chair, you have 7 yeas, 2 nays, 0 pass. The substitute is adopted.
Thank you, Madam Clerk. Next up, we're going to have Rep. DeBoyer moving to report House Bill 4691 as substitute H1. Madam Clerk, please call the roll.
Chair Lightner.
Yes.
Representatives Bagul.
Yes.
Wozniak.
Yes.
Harris.
Yes.
DeBoyer.
Yes.
Johnson.
Yes.
Schutte.
Yes.
Is that Schutte? Carter. Hope.
Yes.
Breen.
Aye.
Scott. Madam Chair, you have 9 yeas, 0 nays, and 0 pass. House Bill 4691 is reported with recommendation as substitute H1.
Thank you. Thank you, members. I forgot to read in one card. So this is in regards to House Bill 4840. Supporting the bill does not wish to speak. Trevor Van Dyke of Scale. With that, seeing no further business before the committee is adjourned.